the problem with Fiona Wolf and the fact that she's had to resign from this committee. Well, not committee, but it's an inquiry, isn't it, into the historic child abuse that's been going on. And I was thinking there's no better indication as to society and the society's health as to how they treat the children, because really our children are the most precious thing that we have. And I think we'd hopefully all agree with that. And what you see very often in the law is a real kind of dichotomy between how the law treats children. As soon as they come out of the womb, there is the utmost care and money spent upon children, especially the most vulnerable children. And you see that very often in my job. And one example was a lady who was a very troubled individual who was urged to have an abortion by social services. And so she was obviously very troubled, and she had a social worker, and they kept on telling her to have an abortion. Maybe not in so many words, but it was certainly encouraged. And then she made a decision not to have an abortion, and all of a sudden, the person who's going to be aborted had its own social worker. So you go from a position of something which is just a byproduct of pregnancy to somebody who is a human, who has its own social worker, and who needs to be helped and cared for, and have thousands of pounds spent on them. So that's just really one example of really sometimes what we see. And these are the kind of the dichotomies, the hypocrisy, really, that very often you see within the law, which I think in this job we really have to expose and confront people with and say, what is going on? What is the justification for this in that particular situation? And so we're going to be hopefully just having a whiz through what the law says in relation to abortion and also in relation to expressive rights. Now, expressive rights is really another name for freedom of speech. In other words, what can you say? What can you get away with? What will land you in prison? So let's have a look at that. So my name, like I said, is Michael Phillips, and I work with the Christian Legal Centre and done a number of cases over the years with Andy, with Andrea Williams, and with various other Christians around the country. So some brief facts, and obviously I'm sure that most people are going to be familiar with these facts here, that generally speaking, in the United Kingdom, we don't have abortion on demand. That is what the law says. So you cannot, in theory, just go into any abortion clinic and say to the doctor, I want an abortion. The reality is something quite different. In reality, really, we do have abortion on demand up to 24 weeks. Approximately 200,000 every year are aborted, and 8 million have been aborted since the passing of the 1967 Act. And so some more statistics. If you look down there, 98%, technically speaking, if you really are going to actually do what the law says, are illegal. So, the question is, why on earth are all these abortions going on? If they're all illegal, why isn't somebody or something happening? And also something else that we could look at is the fact that look at all the babies which are being aborted, especially with special needs, disabilities. Now, the 24 weeks that you see in the legislation really isn't there when it comes to disability. If you're disabled, you can be aborted right up to the very second that you are going to be born. 8 million is roughly 10% of the United Kingdom's population, which is the combined population of Birmingham, Bradford, Bristol, Cambridge, Cardiff, etc., etc. Those are pretty big towns. And those people are gone. They're gone. And it's just, just imagine that. Imagine if there were 8 million Jewish people in this country which had been killed, or 8 million people of another religion, Sikhs, or whatever it is. But, the only difference really between those people and us is a mother's wish. It's not because of their size, because you can't kill somebody because they're small. And it's not because of where they are, because you can't kill somebody because they live in Northampton and you don't like people in Northampton. It's not because of the fact that they can't survive without their mothers, because many of them can. And even if people can't survive without being on dialysis, it doesn't mean you can kill them. The only difference between those people and everybody else is the desire of the mother. The father doesn't have a say over abortion. He can't prevent an abortion. You can't go to a court and ask for an injunction and say, my girlfriend wants an abortion. You can't do that. And the thing is this, is that that's another dichotomy that you see in the law. If, for example, you are a boyfriend and you want to abort your child but the mother doesn't, then you'll be in trouble. You could go to prison for 8 years. So clearly it is the will of the weak. Sorry, the will of the strong over the weak. And that really is the only thing, which is quite frightening, really, because where else do you see that happening? Places like Nazi Germany, where the only reason why the Jewish people were killed was because they were weak and because people thought that they were up to no good and they didn't want them. So there we are. Total abortions per year, dramatic rise after 1967, and a bit of a leveling off, but nonetheless, it's going up still. It's still going up. So the abortion process for 95% of people is this: the pregnancy test, oh no, the referral to BPAS, Mary Stopes, the NHS, no real counselling, and then you have an abortion. And that's really it. 95% of abortions occur between 7 weeks, and that's your 7-week-old there, and 20 weeks. So that is a 20-week-old person, 4 weeks short of viability. And this is really what is kept hidden. And this is why, obviously, the abortion industry doesn't want these photos showed. People are ignorant. People don't know what's going on. And they just want silence. So human development at 6 weeks, 12 weeks, and 18 weeks. I'm sure we've all seen the photos before. And people really aren't ashamed anymore. Here's a lady by the name of Lucy. She became pregnant at 12 after having sex with a 15-year-old. She's too young to understand contraception. Her mother organised the termination. There's no question of keeping the baby. And so it goes on. She's 4 before she's 16. And it's a family affair. It's not just her. It's not just something which is done in secret, done in silence, but it's done openly, and it's just a smile there for the camera. You know, it's not that bad, really. So it's the normalization, really, the normalization of death. So just going back to first principles, this really, the doctors are part of this conspiracy. And going back to first principles, you've got a lot, what do they actually stand for? What do they actually believe in terms of their profession? And this is where it all stems from, that I will give no deadly medicine to anyone if asked or suggest any such counsel, nor in any like manner will I give a woman pessary to produce abortion. So that's really a good thing to take people back to. Take people back to first principles. What is the medical profession all about? It's all about saving lives. It's all about the sanctity of life. It's all about preserving life. And that's what they signed up to when they first became a physician. Something else, our laws are rooted in Christian principles, mostly. And the sanctity of life is something which is very clear throughout the Bible, which once again, you can take people back to first principles. That all people are in the image of God, made in the image of God, and it's a positive thing to take people back to. It's a good thing to say, look, this is what it's all about. And that, God is in favor of life, he's not in favor of death, and the taking of innocent human life is wrong. When is it right to kill an innocent human being? When is it right? You can ask people that. So then, this is the Offences Against the Person Act, 1861. And this is an old act, but nonetheless, this is in use every single day of the week in the courts around our country. Many offences are still under this act, and this is what it says in relation to abortion. Every woman being with child who, with intent to procure her own miscarriage, shall unlawfully administer to herself any poison or other noxious thing, or shall unlawfully use any instrument or other means whatsoever with like intent, or whosoever with the intent to procure the miscarriage. So it goes on, let's skip down to the bottom, shall be guilty of felony. Felony is a very serious crime, and being convicted thereof shall be liable to be kept in penal servitude for life. So this, it says, look, if you do these things, you will go to prison for life. And what do you get life imprisonment for generally? For murder, for the most serious crime. So there was a recognition in our society that this was the case. And this act here is still in force today. Surprise, surprise. But there we have it. This is a more recent declaration of the Doctor's Oath in 1948, done on the back of the Second World War. And this is what they thought at the time. They thought it was important for doctors to affirm that I will maintain the utmost respect for human life from the time of conception, even under threat. I will not use my medical knowledge contrary to the laws of humanity. So whether you approach this from a biblical perspective or from a humanitarian perspective, there was an understanding within humanism that this was the way things should be. And that was also the same year enveloped within the United Nations Universal Declaration on Human Rights. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act toward one another in a spirit of brotherhood. And Article 3 says everyone has the right to life, liberty, and security of person. So just in commenting on that, this is a doctor who says, thus, while Articles 1 and 6 do not explicitly endorse the right to life for the unborn child and a state's obligation to protect that right, the weight of these articles, taken together with the preamble, provide solid ground for a claim that the unborn child is entitled to legal protection under the Convention. So once again, taking people back to the organizations which are most respected and most well regarded, that's what they have to say about life. And again, European Convention on Human Rights, the very controversial court, but really it isn't very often that controversial. And number one, everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which the penalty is provided by law. So it's unequivocal, isn't it? I would argue. But then we have the Abortion Act. The Abortion Act, 1967, brought in on the back of hard cases. So this is very often what happens in law, that you get a very difficult situation. And that difficult situation, people will publicize and they will talk about and they will ask for change in the law. And the Abortion Act in 1967 was that groundbreaking piece of legislation. But nonetheless, they said, look, this is not abortion on demand. Let's be clear about this. There are all these safeguards we're going to be putting in place in order to make sure this does not happen on demand. And what are those safeguards? 2 registered medical practitioners. What is a medical practitioner? Is it a nurse? Is it a healthcare assistant? No, it is a doctor. Nothing else will suffice. And they have to form the opinion. So they've got to sign a form called the HSA1. They've got to sign it. So you've got to have a meeting with a consultation with a doctor. They sign it off. And then a second one has to just make sure that the first one hasn't got it wrong, because obviously it's a big decision. We'll come on to that a little bit later on, because in actual fact, lots of doctors have been pre-signing. So what does pre-signing mean? It means not seeing, which means one medical practitioner, not two, but one. So the profession has changed the law by stealth. So there we are. And they have to form the opinion in good faith. What does good faith mean? That means you actually have to have a bit of a chat. You have to talk through the options with the patient and say, are you sure about this? What's your mental health like? What's your social situation? It's not a laughing and joking matter. It's not just, this is a bit of infanticide going on here. Ha, ha, ha. We do this in the third world. That would clearly be out of the question, wouldn't it? But we'll come on to that in a second. That the pregnancy has not exceeded the 4th week, and the continuance of the pregnancy would involve risk greater than if the pregnancy were terminated of injury to the physical or mental health of the pregnant woman. Now, 98% of all abortions happen under ground C. So this is what they call really the social exception. Because people argue, or doctors argue, that look, if I continue with the pregnancy, or if the lady continues with the pregnancy, there's going to be such mental anguish as a result of this pregnancy that the abortion is justified. So that's what is argued. So there we are. 97% in 2030 were under ground C. So this is what it's all about. Now, apparently we don't have abortion on demand, but we'll come back to that. So ground E. So this is another provision of the Abortion Act, which says that if there's a substantial risk that if the child were born, it would suffer from such physical and mental abnormalities as to be seriously handicapped. Now, can you think of any other situation whereby if I said, you're disabled, I'm not having you on my bus. You're disabled, you've got to sit in that part of the restaurant. You're disabled, maybe I'll punch you in the face and get away with it. But here we are saying that your life is worth less if you are disabled. It is outrageous, and you can't think of any other situation where that would be permitted, but here it is. Now, under ground E, 1%, so this is the most common after ground C, 2,732 abortions in that year. And really one of the most common things is Down syndrome, because nobody wants Down syndrome child, because they're just a bit of a pain, aren't they? They just don't, you don't want them, so get rid of them. But it's not just Down syndrome, is it? It's also things that you can fix, like cleft lip or clubfoot. Now, does it really extend that far? Does it really? Is that really what it says? Going back a couple of slides. And it says that they must suffer from such physical or mental abnormalities as to be seriously handicapped. Seriously handicapped. Remember that, seriously handicapped. Now we're going to be looking at somebody who did have a cleft lip in a second. Finally, ground A, the continuance of the pregnancy would involve risk to the life of the mother, the pregnant woman, greater than if the pregnancy were terminated. So this is ground A. So serious life risk to the mother, which some people might say, well, I can understand that. How many abortions actually occur under this heading? 0.013. It's a very small number. There have been some improvements as time has gone on. The Human Fertilization and Embryology Act, it was no longer legal to abort after 24 weeks, except in cases where it's necessary to save the life of the child. sorry, the woman, I'm so sorry. Wish it was the child. There was evidence of extreme fetal abnormality, or there was a grave risk of physical or mental injury to the woman. So, under pressure, the government saw really what was going on and the fact that many children were surviving who were, I think it was 28 weeks before then. So they had to change it. Why? Because of the exposure, because of the scientific advancement, and it just wasn't tolerated by society anymore. Now, the Human Fertilization and Embryology Act brought about various other things, some of which you may agree with, some of which you may not agree with, but it's all going to the fact that it's the general undermining of the sanctity of life, the sanctity of the embryo. And so, 1967 Acts and the 1990 Acts, now human embryos can be frozen and experimented upon and destroyed up to 14 days. Was that good? Well, they're just embryos, aren't they? And we might get lots of good things out of them. Well, as far as I'm aware, we have never really made any progress with any kind of serious illness as a result of the experimentation which has gone on. And even if we did, the fact is this, is that can you imagine any other society which would experiment on people for scientific reasons? I can think of one, and it's just really we're going in the wrong direction. So this is the tangle of a legal position that really the Human Fertilization and Embryology Act and we as a society in general are in. The human embryo has a special status, but it's not a person. So it's a kind of half person. So this is, it's just, why? What is the justification for that? How can somebody be special but not that special? And then 2008, Human Fertilization and Embryology Act, animal human hybrids. So 3-parent embryos. So these are all the kind of artificial things which have gone on as a result of the gradual breaking down of what society holds as sacred and as good and as worthy to be protected. This, animal human hybrids. It's just perverse. So we go on. Let's go on to the prosecutions. What is actually happening in the courts? That is what is happening in Parliament. What is actually happening in the courts? How are these laws actually being applied? Because that's what it comes down to. It's all very, well and good to have these fine-sounding laws, but if you don't actually use them, it's a bit like having a very nice car in the garage. So this is one of the last prosecutions for the offence of abortion. So this is a doctor, John Smith, in 1973, 6 years after the passing of the Abortion Act, and he made no internal examination, no questions about her medical history, but he did ask why she wanted an abortion. She told him that she was not in love and she was frightened at the idea of childbirth. Asked for £150, which was quite a lot of money back in those days, so cash up front, and said that if she could get it that day, he would operate the following morning. No suggestion for any of a second opinion for further inquiries. Miss Rogers said that it would take her a week to get the money, and he would operate on the 28th. So this is one of the last prosecutions. Pretty, poor standards of medical practice. I'd hope you would agree, even under the terms of the 67 Act. So he did get prosecuted, didn't go to prison, so a good result for him. But that's where we are. So it has to be pretty bad before they intervened, and that was a long time ago. More recent case, this is Joanna Jepson. I don't know whether you've heard of her. She's been on TV quite a few times. She's an Anglican minister, and she was somebody who was born with cleft lip and palate, and her brother has Down syndrome. And she asked the Crown Prosecution Service to prosecute some doctors who were responsible for aborting somebody, a child, with a cleft lip and palate. And the Crown Prosecution Service, the DPP, did what they normally do. They went, we don't want to do this, we don't want to do this. So they decided on the 16th of March 2005 that they have considered that both doctors concluded that there was a substantial risk of abnormalities that would amount to the child being seriously handicapped. The evidence shows that these two doctors did form this opinion and formed it in good faith. So no prosecution. So there we are. So you can get away with it. Cleft lip and palate. It's a serious abnormality. It's a serious disability, allegedly. More recent case, a sentence of 8 years imprisonment for Sarah Louise Catt. She pleaded guilty to administering poison with the intent to procure the miscarriage of her own child at full term. So clearly somebody who wasn't particularly well, it would appear. But it was too excessive. 8 years is too much. 3.5, that's good. We like it. So she'd bought a drug which caused the abortion, which was at full term. Child was never recovered. There was evidence that she'd been researching the termination and abortion drugs since about halfway through the pregnancy. So there we are. Do you know what you get if you murder somebody? You walk up to Andy, you don't like him, understandably. You shoot him. What would you get? Any ideas? Anyone want to hazard a guess? Usually 15 is the minimum. 15 is a minimum. If you murder somebody like your husband or wife in cold blood, want a bit of money, more like 25. 25 to 30. But if it's a baby, 3.5? 8, too much. 3.5, it's good. There we are. Let's come on to more recently. People often don't like girl babies. I'm sorry to say, you're not wanted. And because you're not wanted by certain individuals, you get the job. And there are people who are happy to help. And this is one lady you could go to. She's more than happy to help if you've got the money. Smiling, friendly demeanor, good bedside manner. And she's not the only one. And this is a case which happened in 2012. The Crown Prosecution Service did their usual thing and say, not for us, thank you very much. The 8th of February 2012, E was a pregnant lady, attended a clinic in Manchester. Used a false name. It was a sting by the telegraph. She said that she'd gone to France with her partner and had a blood test there. And we found that there's a really high chance that we're going to have a girl. We don't really like girls, and that's not really appropriate for us right now. We were hoping for a boy. They're a lot better. So we're not looking to have this baby at the moment. What does the doctor say? Well, I'm very sorry. We don't do gender-selective abortions in the United Kingdom. No. She says, no, I don't ask questions. You want a termination? You want a termination. Fine by me. You got the cash? Brilliant. So she then makes the phone call to a colleague, made the arrangements for the abortion. She's had a fetal loss before, at 22 weeks, but this time it's basically social reasons. There we are. It's fine. And what's her defense? She was interviewed by the police under caution. A woman claiming to have discovered the fetus is female when that is scientifically impossible is plainly hiding the truth. It follows that the truth is likely to mean that there are serious problems surrounding the pregnancy, such that a termination would be in accordance with the Act. So I decided to authorize the termination on a basis that she didn't express, but I presume was there because she'd lied to me. I mean, it's just, if you arrest somebody for shoplifting and they said, well, the bloke over there told me that I could do it, and I presumed when he said, no, I can't steal something, he actually meant yes, and so therefore I decided to do it. They go, you're having a laugh, mate. It's just, it's a joke. So what did the DPP decide to do? The 7th of October this last year, there's insufficient evidence to conclude that Dr. Savaraman was prepared to engage in unwarranted gender-selective abortions. There's not enough evidence. So you got a confession on tape, yeah, I knocked him off, but it's not good enough. And that Dr. S was provided with a valid basis of concern, namely the earlier miscarriage of a female fetus. But what about the female fetus? Okay, so there we are. And then this is an expert that we consulted. She said that you can't tell the gender of a child by some blood test, and he says non-invasive determination of fetal gender by analysis of maternal blood is a reliable test which can be performed in the first trimester. The test involves the analysis of free fetal DNA. The test is available in the UK and was available at the time of these cases. So he clearly says, she's telling porcupines. She's in a bit of a pickle. She's told a porcupine, and the CPS say, yeah, that's good enough for us. Don't worry, we'll get you out. We'll row you out. Not a problem. So then on the 10th of February, the same pregnant woman, using a false name, went to the Calthorpe Clinic in Edgbaston. Oops. There we are. Again, there's a conversation between the pregnant woman and the doctor, which she explains that she'd gone to France again, very busy lady, on holiday, found out the gender of the child, which was going to be female. And this is the conversation. Yeah, it's like female infanticide, isn't it? Pregnant woman, can we put down a different reasoning? Because I'm not really not wanting this pregnancy. Dr. Mohan, that's right, yeah, because it's not a good reason anytime. Pregnant woman, okay. So you can't put that down on paper then, Dr. Mohan. I'll put too young for pregnancy, yeah? Pregnant woman, yeah, that's fine. Brilliant. So, his defense, he was taken to the police station, he was interviewed by the police, and he says the abortion was justified on health grounds and that it was a reasonable assessment based on good faith. Did you see a robust assessment of him inquiring about her and her health and her mental health? The practice of pre-signing the forms to sign off is common. And that practice does not affect my judgment. Everybody else is doing it, so it must be all right. Come on. Why are you picking on me? Everybody else got away with the shoplifting. I was the only one that was caught. Why are you picking on me? Is that a defense? So, but the DPP didn't agree. They thought it was brilliant. They thought, we could never get this guy. There was no basis for concluding that Dr. Mohan was prepared to undertake the termination on gender-specific grounds without more evidence. He was given information about the test in France and the previous miscarriage, which he had no reason to doubt. The pre-signing of forms is common practice as stated by the medical expert instructed by the CPS, and such a practice does not preclude later consideration of whether an abortion should be permitted. Secondly, there's no guidance. Nobody's telling us how to have an abortion. No guidance on where the threshold of risk lies, and no guidance on a proper process for recording the assessment carried out. The discretion afforded to the doctor in assessing the risk to the mental or physical health of a patient wanting an abortion is so wide. Having consulted our expert, who we don't know who they are, it appears that there is no generally accepted approach among the medical profession. So there we are. Phew, got out of that one. What actually is the truth? So in the end, the narrow basis of any prosecution is kept firmly in mind. The public interest factors against prosecution outweigh those in favour. So it's not in the public interest. So Crown prosecutors have a code of conduct and they don't prosecute every single crime. So if you're a 90-year-old lady and you get caught stealing a Mars bar, it's not necessarily appropriate for you to be prosecuted, which we can all understand. But generally speaking, the more serious the crime, the more vulnerable the complainant, the more likelihood that a prosecution should take place. But this, it's not in the public interest. So once again, let's turn to our expert, who says it is simply not the case that in order to establish that inadequate and/or incompetent practice took place, specific guidelines are required. This argument effectively means that in all areas of medical practice where there are no specific guidelines, that any standard of practice is to be tolerated. I mean, have a think about it, logically speaking. If there's no guidelines on toe operations, which I don't know whether there are or there aren't, but there aren't for every area of medical practice, and the surgeon accidentally chops off your toe, you can't sue him because there's no guidelines. I'm so sorry about that. We can't do anything about it. It's just, nonsense. In this case, the practice of the doctors concerned, the one choosing to ignore the real reasons for requesting a termination and stating that she did not ask questions, the other falsifying the reasons for termination for having expressed an opinion that this was female infanticide, was so far beyond the bounds of acceptable practice to make it probable not only that the terminations were secured for fetal gender alone, but were also performed without adequate assessment. So there we are. So this isn't somebody who's just, a hired gun. This is somebody who is a consultant, obstetrician, very highly qualified. And he's not the only one. But there aren't that many who are brave enough to actually come forward, because it's not easy when you're taking on the DPP. So there we are. So we're going to be moving on to a different topic now. I've only got about 10 minutes left. But that is the state of abortion in the United Kingdom. Technically, illegal 98% of the time. Practically legal, because nobody wants to actually do anything about it. So, let's talk about expressive rights, freedom of speech. So there we are. I don't know whether you recognize the lady in the red hat. There we are. When I was putting this together last night, I said, can't you get somebody dressed a bit more normally? I said, no, not possible. But yeah, so there we are. So this is unfortunately what happens in this country sometimes if you speak the truth. Now, in this country, we've had a relatively homogenous society up until very recently. Pretty much one religion, one ethnicity, and most of the time we're pretty polite in this country. And so when people say things which are offensive, most people, a lot of people, certainly most police officers think it's a crime. Now, contrast the situation with America, and in America you have the First Amendment. You've probably only heard of the Fifth Amendment. If you were a fan of The Godfather, pleading the Fifth Amendment means the right to non-incrimination, but the First Amendment is actually far more important. It is all about freedom of speech, and it's there in their Constitution. And this is why you have the case of Westboro Baptist Church in America, which is a very odious and offensive church for the most part. They do some pretty distasteful things. They're the ones that have the signs which says God hates fags, and they go outside military funerals. Now, I'm not advocating that for 1 second, but in this country, they'd be serving a 10-year prison sentence. But in America, they're actually allowed to do that because they value the freedom of speech. Even though 99% of people find that very offensive, and it is very offensive and very odious, there is a recognition that freedom of speech means that sometimes you have to listen to things that you don't really want to listen to, or maybe see things you don't necessarily want to see. So this is enshrined within our common law and also within the European Convention on Human Rights. Article 9, everybody has got the right to freedom of thought and belief. Article 10, the right to hold opinions and receive and impart information and ideas without interference from the state. And Article 11, the right to freedom of peaceful assembly. So there we are. It is our right. It is your right to do these things. And our own common law. So these are the rules and the laws which have been developed over the years. And a good case. Case law is what you can rely upon if a police officer comes up to you. This is just one case. It's the case of Redmond Bate, which involved street preachers, 1999. The freedom of expression constitutes one of the essential foundations of a democratic society, subject to paragraph 2 of Article 10. It is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also those that offend, shock, or disturb. Freedom of expression, as enshrined by Article 10, is subject to a number of exceptions. However, these must be narrowly interpreted, and the necessity for any restrictions must be convincingly established. In other words, just because you don't want to hear it doesn't mean it's illegal. Get over it. But, Section 5 of the Public Order Act. This is what Andy was prosecuted for. This is what probably most Christians that I've represented, and many non-Christians as well, seeking to exercise their freedom of speech in a public area, get prosecuted for. Using threatening or abusive words or behavior, or disorderly behavior, displaying a writing or sign or other visible representation which is threatening or abusive within the sight or hearing of a person likely to be caused harassment, alarm, or distress thereby. And it's a defense for you to prove that your conduct was reasonable, and obviously if you're exercising your freedom of speech, I'd argue it's reasonable. And the gravamen, which is a word that nobody really ever uses apart from lawyers, which means the essence of the offense, the essence of abusive, is to really to put somebody down. Now, you think, oh, well, that's, all common sense. But what most police officers actually think, if somebody is upset, offended, and distressed, number one, that person makes a complaint to the police, then an offense has been committed. The suspect should be arrested and freedom of speech doesn't come into it. That's what they actually think when you meet them on the ground. They don't have a clue about freedom of speech. Freedom of speech is just a bit of a dirty word. But let's just go back for a second. Is that what the Act says? They've forgotten the first bit. You have to say something which is abusive. So, okay, you may well be distressed. If I tell you that you're overweight, and you are, that may well be distressing. But is it abusive? No. If I say something pretty offensive about your weight and make fun of you and call you names, that may well be abusive, and that is distressing, and maybe that is an offense. But if I just simply say that you are overweight, it's not necessarily a crime, is it? So this was a case which was not so good and really is something to be avoided. Connolly and the DPP, there's the DPP again, 2007, Malicious Communications Act. This was a lady who posted photos of aborted fetuses to pharmacists that sold the morning after pill. Her defense was that the images were not indecent or grossly offensive, and that she'd sent them with the intention of making a lawful protest and educating against the use of the morning after pill. And the High Court said, go away. The pharmacist targeted at the right not to have sent to the material of the kind sent by Miss Connolly. The conviction was necessary in a democratic society. Her right to express her views about abortion did not justify the distress and anxiety that she intended to cause those receiving the images. So this was how a lot of judges think. And so really, we want to avoid judges very often because, unfortunately, judges sometimes aren't quite like the general public, and they don't necessarily see common sense, and this is how they found. But on to happier cases. There we are, there's Andy. So he faced charges, along with Catherine, under Section 5 and obstructing a police officer. The images were a 10-week-old aborted fetus and 11-week-old aborted fetus in a glove, just near Wisden's clinic in Brighton. None of the witnesses called described the images as abusive, which was a key thing. Now, he won. Andy did not go to prison, which we are very grateful about. Why? The key to winning. You've got to have good facts, good evidence, good behavior, and bad behavior by the opposition. So these are the kinds of cases that should be defended or should be prosecuted. You've got to behave yourself. You know, you may well say that that's, well, you know, it's common sense, but this is what the judge commented on in his judgment. He said, these exchanges are carried out in a polite, civilized fashion. So Andy and the team were not badly behaved. The evidence was good. People make things up all the time. I'm sorry to say, people do, and I see it all the time. People conflate and they confuse, and they maybe intentionally, maybe unintentionally. But the video recording was key. So, on a happier note, things can change. Public opinion changing slowly. 63% of MPs support a reduction in the 6-month upper age limit. 2/3 of the public want a 6-month upper age limit reduced now, and 65% of GPs support a reduction. So people are beginning to see the images. People are beginning to see that actually this is wrong. We need to get the news out there. We need to tell them what's going on. Things like this. And this. The abortion survivors. Ms. Jensen, who was born during the 30th week of her pregnancy, her medical records indicate that she was actually born during a failed saline abortion attempt. There is no answer an abortionist can give, or somebody who's pro-abortion, when they meet somebody like that. This is a real person. Born in a clinic, the owner of which boasts that he's aborted over 1 million babies. And that was her delivering doctor. She was born, and he wasn't actually on duty when she was born, and that saved her. Because otherwise, they'd have finished her off. The images change mind. So the 3D images which have recently come out, apparently that was one of the major things that really struck people in more recent years. A number of MPs have commented on that. Get the message out. Fetal pain. Tell people the truth. Under 26 weeks, surprise, surprise, people, children, can feel things. Survival rates, they're increasing. 1995 shows the survival of 23 and 24-week children at 11 and 26%. And if you're in a really good hospital, it goes up to nearly 80%. So this is, again, an argument to be used. Why 24 weeks is no longer any good. Getting the news out there in relation to the health effects as well. Mental health. The British Psychiatry paper, September 2011, shows 80% higher mental health problems after abortion. It isn't problem-free. And remember, Ground C says that you can have an abortion if basically your mental health would suffer as a result of you continuing with the pregnancy. But the science says the opposite, that if you have an abortion, you will be damaged. So after the scandal with the two Telegraph doctors, the Department of Health said some good things and some bad things. It said pre-signing of HSA-1 forms is illegal. Abortion on the grounds of gender alone is illegal. Failure to notify the department is a criminal offence. But at the same time, they're saying, well, no doctor needs to see the patient and nurses can do most of the procedure. Going back to the Act itself, 2 registered medical practitioners. So, realizing it's been going on for far too long. The opposition is strong, but really, I'd say that we have the stronger case. But we're not saying anything. We're not doing anything. Finally, call to action, speaking out, get tender, get trained. You've got to know the facts, you've got to know the arguments. There are so many facts, there are so many arguments which are there, which are irrefutable. Bringing about legal change will not happen until the public change their opinion. That is the bottom line. Because really the courts are just a reflection of what society as a whole thinks. And they do not want to be out of step with society. Now the reason why Fiona Woolf had to step down is because there was too much pressure, there was too much heat on her. But at the moment, public opinion, broadly, is in favour. But if that changes, then really the law will change, or really the implementation of the law will change. The DPP will change. They will start to prosecute people. People will start to get afraid of carrying out illegal abortions, and things will change. But in order to get to that, people have to stand up.